Good morning, everyone. Welcome back to the public hearings of the TRRC. Imam, you have the floor. If you can offer some prayers, please.
Thank you, Chair. Let's start with a universal prayer. The fact that our bishop is not present today, so each one person will pray in his own tongue, since we speak in tongues. And then I will conclude the prayer with the Islamic way of prayer. Thank you. الحمد لله هدينا لهذا وما كنا لنهتدي لولا أن هدينا الله الأول والآخر والزاخر والباطن يا ربنا لك الحمد يا ربنا لك الحمد كما ينبغي وجلال وجهك وعظيم سلطانك وصلى الله على سيدنا محمد خاتم النبيين وإمام المرسلين ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار سبحان ربك رب العزة عما يصفون وسلام على المرسلين الحمد لله رب العالمين الحمد لله رب العالمين آمين.
Amen. Shukran, Imam Jallo. Council, if you are ready with this morning's witness, you may proceed, please.
Good morning, Mr. Chairman, commissioners, and members of the audience. May the witness be called in, please. Thank you.
I, Neneh Cham.
I, Neneh Cham.
Do swear.
Do swear.
I will speak the truth.
I shall speak the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
So help me God.
So help me Allah.
Thank you.
Good morning, Ms. Cham. Welcome to the TRRC.
Thank you, Council.
And thank you for agreeing to testify before the Commission. Ms. Cham, we do allow for interpretation in one of the local languages. Could you kindly choose the language, the local language in which you would wish your testimony to be interpreted into?
May I have Wolof, please?
Wolof, please. Thank you. I think the Wolof booth is already seated and settled. Thank you very much. Just as a matter of procedure, we do warn witnesses before the Commission that it is an offense under the laws of this country to lie under oath, and it is also an offense to provide false or misleading information to the TRRC. These are things that you know better than I do. But nonetheless, we just make that warning for the purposes of the record. You are called here today to testify about your experiences of human rights violations as you practice law in this country, but also your perspectives into how the justice sector institutions were abused by the executive between 1994 and 2017 for the purposes of entrenching Yahya Jammeh's government, or for the purposes of satisfying the wishes of the executive. Are you ready to?
Yes, sure.
Thank you very much. Could you kindly tell us your full names, please?
My name's Neneh M.C Cham.
Neneh M.C Cham.
Date and place of birth?
I was born 17th May 71 in Basse.
17 fukki fan ak juroom ñaar ci wéri May ci Basse.
Neneh, kindly wait for the interpretation into Wolof before you respond. You know, there is always that temptation to just immediately respond upon hearing the question. So tell us about your education.
Well, I attended Marina International School, primary.
Marina International Primary School.
I took the common entrance in 1984.
Ci atum 1984 ma daldi def natum xam-xam common entrance.
From 84 to 89, I attended Gambia High School.
Ci atum 1984 be 89 ma ngi won Gambia High School.
Did my A levels in 8 subjects, I believe.
Ma def nak suma A levels ci juroom ñetti fànnaay njàng.
I then went to the United Kingdom and attended Connaught College, where I did my A levels.
Ma dem nak United Kingdom fofu la defé suma A levels di réewi Angleterre.
In English, law and politics.
Ci làkki anglais ak mbiri politics.
And then I finished in 92, I believe. 91, 92, I went to Buckingham University of Buckingham.
Ma jeexal fa 1991, 92 ma dem Buckingham University.
At University of Buckingham, I got an honors degree in English and European law with French.
Ci foofu nag jàng am naa fa nag maxam nattu xam-xam bu taaru lu jëm ci wàlli English ak tamit law.
Actually, prior to that, French. I had to do a pre-sessional course in Université Catholique de Lille in France from September 1992 to December 1992, prior to starting the course.
Njàng mu jiitu nag boo xam ne nii def naa ko ci réewi France lu jiitu nag njàngam university boobu leen mu nettali.
And I then took some time off. I graduated in 1995, shall I say?
Ci atum 1995 nag ci laa jeexal njàng moomu.
I took some time off, and in late 1999, I went to Sierra Leone Law School.
Ma def toog nag ab diir di noppaleku ci njeexteel atum 1999 ci laa dem Sierra Leone ci seen school bi jàng wàlli loi.
And did my bar finals there.
Foofu nag la jeexale nag lu aju ci wàlli mbiri lawyer.
I came back. I was enrolled in Sierra Leone, and I came back in 2000 November. I was enrolled Gambia Bar.
Ci weeri November fii nag ci réewi Gambia mu dugg nag ci loi bi ci buntu bi saytu wàlli lawyer fii ci réew mi.
So from 2000 to date, I've been in private legal practice.
Depuis nag 2000 ba jamono bi muy wax ak yow wax fii moom lawyer la boo xam ne nii mu ngi dox nag ci mbiri layoo yi.
Thank you very much.
Jërëjëf.
Your practice as a lawyer has put you in a situation where you encounter how recognized rights or constitutionally guaranteed rights are being applied in various sections or institutions within the justice sector infrastructure, including police, NIA, and prisons.
ci sa wàlli liggéey bi nag dugal na la ci buntu ci bari yoo xam ne xam nga ci ni nga xam ne noonu la ñoo saytoo doxini luwaa ci yoon ci wàlli police bi ci wàlli NIA ak ci wàlli prison.
Yes.
Wow.
We want you to talk about those experiences.
dañ bëgg nag nga waxal ñu nag ci wàlli xam-xam yooyu nga xam ne moom nga am ci bunta yooyu.
Starting with the police.
Nga doore ko nag ci bunti police bi.
Interactions with the police, things that you saw at police stations, and how your clients were treated in these institutions and so forth.
Sa joko wante ak police bi naka nga sa client yi ci police bi naka ngeen doon jëflante ak ñoom ak yu mel noonu.
Well, as a private legal practitioner, I defended many people.
Comme ni lawyer bo xamne ni nak lawyer yi dox dépasse la may liggéeyal suma bop dan na baddu ay nit ñu bari di len taxawal ci ATK yi.
At Basansang Chambers with my senior A.N.M. Ousseynou Dabo.
Ci Basansang Chambers fofu moy seen buntu ATK seen lawyer bi ak kilifam Ousseynou Dabo.
When I went there, I found that much of the work that he did was around human rights violations.
Moom fa demee nag gis naa ne liggéey yu bari yi nga xam ne nii mu ngi ko doon def nag mooy baddu lu aju ci wàlli ni ñuy xëttee yelleefi doomu aadama.
So I have had cause to visit arrested persons in various police stations
ci jamono boobu nag
across the country.
naa de am na gëdd pour nag nemmeeku ji ñu bari ñoo xam ne nii ñu ngi leen jàpp ci police station yi.
From my experience,
in
ordinary cases, I had little or no problem.
But
where, it seemed to be where it was a political case, for example, where the state had interest, where very sensitive, or cases in which they were very sensitive. I encountered some resistance from the police in providing information about the whereabouts of arrested persons.
Thank you for this. But help us understand what you mean by political cases or sensitive cases, that category of cases which often presented certain difficulties, resistance and so forth. Which type of cases or whose interests are we talking about here?
Waaw jërëjëf buñ bëgg na nga gën ñoo leeralal rek façon ngi case yi nga wax nii ne doo ci am jafe-jafe ak yan ñooy façon ngi case yi nga xam ne dinay aajoo ak ñan lay aajoo.
Well, these are cases involving, for example, politicians.
Lii mooy yenn case yi nga xam ne ni ñi ci dugg daal mooy ay politicians yi.
Cases of treason, for example, where people have been accused of wanting to overthrow the government. Cases in which I would say the president, former president, and had interest. Sometimes it may not be too obvious even what the interest is, but you get the feeling once you begin to handle the case, you get the feeling that there's some interest in this.
ñaare nak li nga xamne ni moy aajo bam ci am du feus ben nit ñi xam ko waye nak so duggé be ci biir rek da nga am yeg bo yeg ne dal amna aajo bo xamne ni nat nako ci layo bobu.
Cases of civil servants, for example.
Lu melni ki ñi nga xamne ni ñoy liggéey ci nguur gi.
Where
would you say that one common factor in all these 4 different strands you mentioned, one common factor is the interest of the president in the outcome. Would you say that?
ndax di nga mën a wax ne ñeenti bunta yi fànn yi nga wax ni yëpp ca fa nga xam ne daal fa la cocc te ngay nekk daal itey président bi la dee faral di doon.
I would say so, because you would be told by officers and other people you encounter as you go about doing your job that orders were coming from the top.
waaw danaa wax loolu ndax léegi mën na amat sax ñi ko yëgal mooy ñi nga xam ne ñooy liggéey ak ñoom te dana feeñal sax ne ndigal li mu ngi jóge koo ci kaw.
Okay. So continue with your description of your encounters at the police stations.
waa léegi nag eggalil pour leeralal ñu yi nga xam ne muy yëg-yëg yi nga am ci police station yi.
Yes, sometimes it wasn't always easy to have access to clients, certain clients.
léegi nag du daan yomb rek pour mën a gisanteeg yenn client yooyu.
Because you'd be told that the various senior officers were not around. You'll be given excuses.
léegi danañ la layal lay yu bëri bokk ci daan naan laan kilifa yi yenn yi nekk fi ci office bi ñëwooguñ.
And in the meantime, time is running. Somebody has been arrested and they've been held for days and days and beyond the 72 hours, most of the time.
te jamono boobu sax day waxtu waa ngee gën a dem rek nit ñu ngi ko jàpp teg ko benn place lu jéggi li nga xam ne loolu la lu maye di ñetti fan.
And one important right for any person who is arrested by the police is to have access to a lawyer.
benn ci yelleef yi nga xam ne nag am na solo lool ki nga xam ne dañ ko jàpp pour moom itamit mun a am koo xam ne lawyer la bu koo taxawal.
Yeah, that's right.
waaw loolu dëgg la.
How often would such right of access to a lawyer be either denied or delayed in cases in the 4 categories that you've mentioned?
Oh, almost always.
naka la daan faral di amee jamono joo xam ne nag borom am na yelleef pour mun a jot ci lawyer ñu aaye ko ko wala ñu yiixal ko naka la daan faral di amee.
Almost always.
daanaka daal waxtu wu ne la toujours.
Can you give us a few examples of this denial or delay of access?
mën nga ñoo
By
jox
citing cases that you can remember off the top of your head. Sorry for putting you on the spot on that, but seeing that it happens almost always, perhaps it may not be difficult to remember 1 or 2.
mën nga ñoo jox yenn ci misaal benn wala ñaar ci yoo xam ne war nga koo mun a fàttaleku comme que lu daan faral di am la xëy na du ñàkk yoo xam ne mu ngi ci sa xel mi ba léegi.
Yes, there are many. I mean, I'll begin with my senior, Mariam Denton.
bari na damay doore sax kenn ci suma kilifa Mariam Denton.
She is the doyen of the female lawyers.
bokk na ci ñi nga xam ne ni ay lawyer yu jigéen lañ.
The doyen, she was the first female lawyer.
bokk na ci njëlbeeni lawyer yu jigéen yi fii.
When she was arrested in 2006.
jamono biñ ko jàppee ci atum 2006.
We tried. I personally, we tried to see her.
daal def nañ jëflante fexe nañ ay yoon man ci suma bopp sax fexe nañ pour gis ko.
It's just an example of the denial of access. But even though this one didn't happen at the police station, it was at Mile 2 Central Prisons.
comme rek pour seet nag li wax nag li nga xam ne ni mu ngi aju ci wàllu ni ñu lay xañee lu jëm ci mbiri lawyer ndax bii amutoon ci police station yi waaye mu ngi woon ci kaso gu mag yi Banjul Mile 2.
Which I can speak about a bit later, perhaps. Another example would be Lamin Tunkara.
loolu nag danaa ci mën a wax ci gannaawaan kanam tuuti waaye beneen bi mooy Lamin Tunkara.
Was arrested along with the, what I later understood to be a group of West African migrants.
ñu ngi ko jàppoon nag ñeneen ñoo xam ne ni nag mujjee gi laa xam ne daal ay doxandeem yoo xam ne nii ñu ngi jóge ko ci diwaani Afrique sowu jant.
I wasn't initially denied access to him.
ca njëlbeen nag aayewuñu woon ma nag pour ma gisanteeg moom.
But when I went back with the court order for his release.
waaye bi ma demaatee nag ci ànd ak ndigal boo xam ne nii pour mu ngi tukkee ci court bi pour ñu bàyyi ko.
I saw him.
ma gis ko.
And but the police wouldn't release him.
waaye nag police yi nangu yoon koo bàyyi.
They kept saying that such and such senior officer, OC is not here. Just basically.
dañ daan nekk rek di wax naan diw ak diw kenn kilifa nangam daal di joxe ay lay rek.
Until suddenly they said he was no longer there.
ba mujjental gi ñu mujjee wax ne daal nekkatul fa.
I have had colleagues arrested also.
am na ay suma yeneen nawle yoo xam ne jàpp nañ leen.
Held at either the police station, because here they usually would sometimes be at the police station, sometimes at the NIA. ñu dem téye leen ci police gi fii nag léegi ci police ga wala sax ci buntu liggéeykaay NIA. But sometimes in these cases, the way the police received you.
waaye fii nag léegi ni nga xamee noonu la police di dalale.
Sometimes you could see that they were trying to do their job, but were constrained.
léegi nag dafay mel ni sax ñu ngi def seen liggéey waaye nag ci ak ay jafe-jafe.
But what do you think constrained them, either based on what they have told you or what you have observed?
nga foog ne nag loolu moo leen dee tënka ci niñ la ko dee waxee la wala yow ci sa seetlu boppa.
Oh, I've had officers, because some of us had good relations with some of the police officers, and they would tell you, really, I want to help you, I want to give you access to your client, but I can't, I have orders not to.
waaw léegi daal xam nga am na yenn police yoo xam ni sax am nañ jokkoo bu rafet léegi dañ lay wax ne la bëgg naa laa wane leeg sa client bi de waaye nag amoon ndigal bi.
Because they would always say they were still investigating.
ndax mujjee dañ lay wax rek ne la ba léegi rek ay mbiram ñu ngi koy gestu ba tey.
And they considered giving the lawyer access as, interference.
te ni ñuy gisee rek ne buñ la joxee jotaay pour nga gis sa client bi rek moo nekk ne dangay dugal sa loxo ci gestu bi ñooy gestu.
What's the problem here? Is it lack of knowledge on the part of the police that, in fact, allowing lawyers to, or allowing clients, suspects to confer with their lawyers is part of the investigative process? Or is it just blatant denial of access on the basis of instructions they may receive?
ban la ci nag ndax ñi nga xam ne ñooy police yi ñàkk xam-xam boo xam ne am nañ ko ci ne ki nga xam ne moom lañ téye dafa war a gisee ak looyaam te loolu bu ko defee dafa mel ni ñu ngi dugal loxo ci gëstu bi wala boog dañ tey teelu rek bañ rek pour ngeen gisante ak seen
I think it's both.
yaakaar naa ñaari yëpp la.
I'll give you an example.
naa la jox benn misaal.
This happened at the prisons.
lii mu ngi xew na ci kaso gi.
When my clients, I went there to see Bailo and others.
ci jamono bi nga xamee nag suma client yi benn dem naa pour gis Bailo ak ñeneen.
My instructions were that they were in detention, incommunicado for almost 2 years.
ñoom nag ñu ngi leen téye ci benn place boo xam ne nii duñ war a gisanteeg wala wax ak kenn fi diiram ñaari at.
I went to the gates, and as soon as I gave their name, they're usually very cooperative, but as soon as I gave the names, they looked at each other and then they referred to senior officers.
waaw ci njëlbeen nag danañ dee ànd ci wax ji de waaye nag boo tuddee tur rek ñu xoolante rek commencé di la ebal ci ay kilifa.
I waited while they consulted with their seniors.
ma toog di xaar waxtu woo xam ne ñu ngi wax ak seen kilifa yi.
And then they referred me to one of the commissioners of prison at the headquarters.
ci booba nag ci lañ ma ebal ci kenn ci police commissioner ci kilifa yooyu ci seen màkkaan gu mag gi.
When I went, he received me very well.
bi ma demee nag mu dalal ma bu baax.
I had fairly decent rapport with all of them.
amoon naa jokkoo bu rafet ak ñoom nag daanaka.
As soon as I mentioned, he said, "What do you want, counsel?"
mu laaj ma nag loo soxla counsel.
As soon as I mentioned the names,
bi ma tuddee tur yi rek.
he said, "Oh, no, you can't see those people."
ci la ma di mënuloo gis ñooñu.
No, those people have nothing to do with the court.
ci la ma wax ñooñu nag amuñ dara loo xam ne ñu war nañ koo jëflante court bi.
He was trying to educate me.
mu ngi mel ni ku may jéem a jàngal.
He said to me, no, those people are detainees.
ma ne ñu jàpp teg leen benn place la.
They are not remanded by the court here.
ñoom nekku ñoo xam ne ni court bi moo leen fi teg.
I said, yes, I know they're detainees.
waaw xam naa ne ñu jàpp lañ.
Was that a suggestion that detainees are not entitled to access to lawyers?
Definitely.
Well,
and he further explained He said these people are brought here from the top, from the executive.
ci la gën a leeral sax ne ñii ñu ngi leen agsi fii rek ci ndigal lu jóge ko ca kaw.
I said, yes, I know. I'm here to see them as their lawyer.
ci la wax ne waaw dama ñëw fii pour gis leen ne maay seen lawyer.
One thing that became very clear during our institutional hearing on the prison was the fact that such detainees were admitted to prison without any single document or authority. Was that your experience?
li nga xam ne nag moom lañ jot ci CD bi ñoo gëstu mbiri liggéeykaay yi lañ jot ci wàllu prison bi mooy ñi nga xam ne ñoom lañ fay téye du am benn këyit sax boo xam ne lu aju seen mbir la boo xam ne dañ ko fa.
Certainly, he confirmed that to me.
loolu la wéral ci man.
But he thought that was okay. That was the worrying thing about it. He thought it was okay. You know, it's like, okay, you only hear lawyers are only allowed to see those that are going to court or likely to go to court, but not others, as though they were just entrusted to them to keep for till whenever, and they will hand them over to whoever entrusted them to.
Would you agree that such a system was a good platform for enforced disappearances of people?
nag foogul li nga ànd nag ci ne façon yi doxalin boobu noonu dafa ubbil bunta rek pour jékki-jékki ñi nga xam ne dañoo jékki-jékki rek ne meles kenn du leen gis.
Certainly, because there was no account for those people that were there.
Again, for these prison officers, is it your experience that they acted in that manner purely out of lack of knowledge, purely as a result of that they did not know the applicable rules, or was it just blinded implementation of orders they may have received from above?
ndax yow ci sa wàlli gis-gis ñi nga xam ne ñooy liggéey ci prison bi ñoom ñàkk xam-xam la rek pour doxal li nga xam ne loolu la yoon wi laajte wala ñoom dafa doon loo xam ne rek kàddu gu bàyyeekoo ci seen kilifa yi moom la ñoo jëfee.
Certainly, it was lack of knowledge.
waaw loolu daal li ko lal yëpp mooy ñàkk xam-xam rek.
Because of the way he spoke to me.
ndek ni mu doon waxee ak man.
It showed me that he was completely ignorant of what the law required.
But
it also showed me that he was terrified. To even consider letting me have access. So it was convenient for him to just say that.
David Colley testified before the commission, and he suggested that for these security detainees, the prison officers had no control over them. They had no authority over them. Their role was to just keep them. Did your experience suggest that fact?
David Colley wax na fi ne ñooñu nga xam ne yenn ci ñi jàpp foofu la ñoom ñiy liggéey ci prison bi wala prison bi foofu amuñ benn kàddu ci seen kaw dañ leen ñëw rek dénkal leen ko pour ñu dencal leen ko ndax yow noonu nga ko gisee.
Yes, I agree, because that is precisely what the prison commissioner told me.
waaw nangu naa ci loolu kañ ndax daanaka loolu sax la ma prison commissioner bi wax.
Apart from the problem of access to suspects in whose cases the president had interest, what are the other problems that you have encountered, say at the level of the police, with regards to such type of suspects?
Gannaaw jafe-jafe yi ngeen di am nag pour mun a gisee ak seeni client yi nga xam ne président bi am na aajo ci ay mbiram yan yeneen façon yi jafe-jafe ngeen di faral di am ci ñooñu.
Well, if they eventually grant you access,
gannaaw boo xamee ni sax jox nañ la pour nga gis ko.
They would literally be standing over you as you consult with your client.
dañuy taxaw tiimu la gannaaw boo xamee yaa ngi waxtaan ak sa client.
They won't allow you even private consultation?
No. nangu yéen ñaar rek ngeen diisoo ci secret.
They would literally be standing over you. And sometimes we'd ask them to move, but you had to work with what you had. If it meant going without seeing the client, you will just manage.
dañuy taxaw tiimu la de léegoo-léeg sax dañ dee sàkku si ñoom pour ñu dem waaye duñ ko def léegi li ngay def rek mooy ci ak ñàkk pexe rek nga jël li nga xam ne loolu nga ca am wax ak sa client.
Some have testified here and talk about the issue of bail, that one of the biggest problems is the issue of bail. Was that so that your experience?
am na ñu fi joxe seeni seede tam wax nañ ne ñoom bokk na ci jafe-jafe yi ñu daan am mooy mbiri bail ndax yow tamit loolu dal na la.
Yes, in numerous cases.
waaw ci ay case yu bari.
What methods would they normally use to frustrate bail applications?
ci lan lañ dee sukkandiku nag pour yaaxal li nga xam ne moo di bindu yuñ bind pour ngeen sàkku ñi ñu am bail.
Well, they thought that as long as they say that they're still investigating, that justifies continued detention without being taken to court.
waaw léegi bu ñu fekkee ne wax nañ ne de ñoom ba léegi ñu ngi gestu loolu moo wéral rek ne daal ba léegi rek dañ koy teg benn place ba jamono bu ñuy dem court.
Isn't there a realization in the police that the whole essence of denying bail should be, or rather denial of bail should be premised mainly on the flight risk of the person and no other consideration? Or the possibility that if this person is released, the person would destroy evidence that is available.
ndax doonut yëg-yëg rek ci police bi ne borom buñ ko bàyyee xëj na dina daw wala mu yàqa li nga xam ne moo di seede yi ñoo war a soxla ci wàlli gistu bi.
Well, that ought to be the consideration, that ought to have been, but it wasn't. In these cases, I mean, as I said, in ordinary cases, there's no problem there. Almost always they would either charge or release after the 72 hours.
waaw léegi de ci noonu la war a nekkee de waaye nag comme su fekkee ne case boo xam ne nii case yu ordinary la rek ñaare da ngaa gis rek ñu teg ko ay tuuma yi ñu ko war a teg tuuma wala ñu bàyyi ko balaa ñetti fan yi.
But in cases in which there was interest.
waaye nag ci yenn case yi nga xam ne nii dañ ci am aajo.
They wouldn't release.
duñ la bàyyi.
And that distinction is very clear, that the way they proceed with cases in which Jammeh had interest was completely different from other cases in which there was no such interest.
Certainly.
Loolu firnde gi set na dinañ koy nangul yeneen case yi waaye duñ ko nangul ñi nga xam ne Yaya Jammeh moom itteem a ngi ci loolu.
How about the issue of torture?
Nakan mbiri mitital yi nag.
In police stations.
Police station yi.
We would come to that with regards to the NIA and other institutions.
Dinañ ñëw ci loolu nag ci aju ci mbiri NIA ak yeneen liggéeykaay.
But your experience is with the police.
waaye yow daal ci saw mbiri jokko ak police yi.
Have you encountered instances of torture?
ndax ñëw fekkee nga ci wala yëg nga ci dara lu aju ci mbiri mitital yi ñeena teg.
I have had some clients, not many, that have alleged slaps, being slapped, etc., but not at not the severe forms of torture at the police station. However, that's from my personal experience. However, I had a matter, I believe it was Samba Doroba, that alleged severe torture at the hands of the police. I think he gave evidence before this commission of acid being poured on his private parts.
Fànn yu dëppoo yooyu ci mbiri police bunti police yi am naa client yoo xam ne nii dañ leen tawal rek ne comme dañ leen mbécc waaye nag nekkut comme métital yoo xam ne nii yu jéggi dayo.
Not that that is not serious.
waaw yoo xam ne nii méttiwul noonu waaye nag.
nekkut ne loolu duwut lu garaaw.
waaye nekkut lu garaaw waaye am naa ci benn ci client koo xam ne nii Samba Doro Ba moom nga xam ne nii wéral na fii sax ne dañ sotti woon asib si ciram.
You recall, Mr. Chair, Samba Doro Ba testified before the commission. I think the alleged perpetrator was Modu Pika Jallow, if my recollection is right. Yes. So yes, we do have that information.
Yes, but most of the severe tortures happened at the NIA.
At the NIA.
lu bari nak ci yu metti ci mettital yoy mu ngi amé ci NIA.
But also in terms of frequency of torture, was it rife at the police or was it not? Based on your experience.
Faral di amé ci wàllu mettital dina amé ci police ba wala du fay amé yow ci sa wàllu yëg.
In my experience, it wasn't rife.
ci suma yëg-yëg nak du doon bari noonu.
It wasn't rife because most of these suspects didn't spend too much time at the police. That's what I think.
ndax lu bari nak ci ñooñu ñu jàpp daal duñ daan yàgg ci loxo police.
Okay. Other than how about the issue of remand? Because police prosecutors were generally responsible at first brush in dealing with some of these cases. How was the issue of the issue of remand dealt with? Well, it's the corollary to bail, but perhaps I should revise the question. The issue of holding charges, how was it dealt with by the police in cases in which the executive or Yaya Jammeh had an interest?
Naka lañ daan jëlee nag ca police ba pour dal di teg nit ki li nga xam ne moom lañ ko tuumaal ci ñi nga xam ne ñu ngi leen fa téye te bi fekkee na Yaya Jammeh am na ci itte ñoom naka lañ daan jëflantee ñoom ci mbiri biir.
Well, they will use it whenever they need it to sort of buy time.
dañ ko daan jëfee saa buñ ko soxlaa ngir rek ngir a yaatal waxtu wi.
And they were in the habit of even charging in the wrong court.
léegoo-léeg sax dañ koy def nag jikko ko ne di ko teg ay tuuma ci court boo xam ne du court bi mu war a dem.
And then hope that the magistrate would remand until they're ready to file at the High Court.
ci kaw yaakaar boo xam ne rek ne magistrate bi.
It was abused.
dana ko remand ba jamono boo xam ne dañ ko toxal ci court bu gën a kawe.
And we understand, or we've received evidence suggesting that the executive did not hold too kindly to magistrates who would not comply, especially in cases where they're interested in. And the example that is cited is the case of Said Mati Jau, who was not in fact that one. Yes, Said Mati too, that happened. Said Mati was acquitted. But for the purposes of holding charges, there is this instance of, say, present-day Justice Jaite, when he was a magistrate. A person was charged before he is caught in Birkama. He believed he did not have jurisdiction, and he released the guy and asked that the case be taken to Bundung Court, which had jurisdiction. He was subsequently arrested and detained for doing that. Was that kind of experience, was that kind of situation common?
With lawyers, you mean?
No, with say, magistrates and so forth.
Yes, it depends. As I said, it depended on the case and whether there was interest in it and whether the magistrate would play ball.
waaw wax naa fi rek comme ni ma ko waxee kon mu ngi des rek ci li nga xam ne ni ñoom am nañ ci aajo ak nga seet ndax magistrate bi dana ànd ci seen kàddoom déet.
I don't have personal experience, but it was commonly known that some of them received instructions.
amuma nag ci boo xam ne nii jëflante la ci man waaye nag am nañ ci yoo xam ne nii yëg-yëg ne danañ daan jot ndigal.
As to whether or not they should grant bail.
ndax dañ war a grant bail wala déet.
We would come back. We would come back to that.
Sorry,
issue.
we keep going back and forth. But
yes, we'll come back to that issue when we talk about interference, because perhaps maybe that forms the one of the most significant aspects of interference in the independence of the judiciary. But let's now talk about the NIA with regards to this problem of access, torture, denial of bail, and things like that.
léegi nag ñu ñëw ci mbiri NIA ci nga xam ne lawyer dinañ ci jotee seen client yi wàllu bail ak yu mel noonu.
Well, I've never been allowed access to my any client that was detained at the NIA.
mosuñ ma may nag yoon pour ma gisanteeg suma benn client boo xam ne nii ñu ngi ko téye ci NIA.
Have you had clients detained at the NIA?
Musoon nga am ay client yoo xam ne ñu ngi leen téye NIA.
Yes, I can cite an example of a colleague that was there.
Waaw, man naa cee wax sax benn su may nawle yoo xam ne mu nga fa woon.
And we tried to, myself and Mrs. Sagar Jahate tried to see her, and we couldn't. We were denied access.
Man nag try fexe woon naa man ak Mrs. Sagar Jahate pour gis ko waaye daal ay mayu ñoon ñu gis ko.
On one occasion, because I persisted, and one occasion I went and I was allowed in for the first time.
Maa ngi fàttaliku benn jamono sax de demoon naa bañ may nañ ma dugg.
I saw the DG and the deputy, Sen, I believe, and Sen and Yankuba was then Yankuba Baji was then the deputy.
Ma gis fa nag ki borom kër gi ak ki ci topp Sen ak Yankuba Baji yaakaar naa jamono boobu moo toppoon ci ki jiite.
When I was allowed in, I had high hopes that I would see her. I'd been there for over a month.
Biñ ma maye nag ma gis ma dem yaakaaroon naa sax ne dinaa ko gis ndax boobu mu ngi fa woon su dem si dira benn weer.
But eventually they said investigations were still going on and I could not have access. I was disappointed.
Moom nag after mujjee gi nag ci lañ ma wax ne ba léegi ñu ngi def ay gestu kon mënuma koo gis maa moon ci ak tas yaakaar nag.
We will ask the same questions of the NIA. Did those officers you spoke to, did they have knowledge that or information that the client, that the suspect or the detainee had a right to speak to you as her lawyer?
ma laajaat la rek la ma la laajoon ca police ya ndax NIA ñi fa nekk di liggéey ñoom am nañ xam-xam bu mut pour xam ne lawyer bi dafa war a gisee ak ki nga xam ne moo di kiliyaanam biñ téye.
I believe they did because they were senior.
Waaw yaakaar naa ko ndax ñoom ay kilifa lañ woon.
But in spite of that, they decided to refuse access.
Yes.
Waa ak liñ ko xam yëpp terewut dañu tere la pour nga gisante sa kiliyaan.
Yes, they didn't confirm that she was there. They didn't deny that she was there either.
Weddi wuñu ma dëggalu ñu ne mu ngi fa waaye nag weddi wuñu ni tamit ne mu ngi fa.
I remember at the time, Council Jobate was also being detained there with some other people.
Council Jobate mooy boo mu ngi fa ak ñu jàpp ko ak yeneen i nit. When
he was suddenly brought to court, I was in court, Banjul Magistrate Court, in another case.
Binko indee nag ci court ci Banjul Magistrate Court boobu maa ngi woon foofa.
Before he was taken away, he spoke to me and said, "Neneh, we saw you the other day when you came. Please just insist." Just there, insist on seeing her.
Ci la ma balaañ ko yóbbu ci la ma gis mu ne ma Neneh gisoon nañ la keroog bi nga fa ñëwee continuer rek dingatal rek mu ngi fa.
From what we have heard so far in this commission, it appears that the NIA would consistently deny detaining people in whose case the executive had an interest.
ci li nga xam ne day moom lañ fi jotagum fii ci ay seede mu mel ni waa NIA yi dañuy continuer rek di bañ ñu mun a gis ña nga xam ne ñu ngi leen fa jàpp te fekk nag yi nga xam ne ñoo di kilifa yi ñoom ñu ngi ci am itte.
dañuy bañ a nangu ne ñu ngi denc ñeneen ñi ci seen place su fekkee ne nguur gi amoon nañ interest ci ñooñu seen case.
Yes, yeah, that is right. That is correct.
dëgg la.
Because if they in fact, getting through to the gates was a problem, as I said, just the one-off that you'd allowed in. So they would never confirm at reception whether the person was there. Well, so you wouldn't know.
Ci fi nga xamne moy daluway ba sax lay fofu duñ la fa mossa nangul sax ne la mu ngi fofu ci jamono bu.
Yes.
But for much of these cases in which the executive had an interest, from your experiences, where were they more dealt with? Was it at the police or at the NIA?
ci ñi nga xam ne nag ñaareel kilifa yi dinañ ci am aajo lool fan lañ leen dee faral di teg ci NIA wala ca police ba.
Certainly the NIA.
lu ci bari daal ci NIA gi la ñu gën a leere.
And it looks like there is one common thread, some common standard that happened in most of these cases. For all cases where the executive is interested in, there is denial of access at the police, at the NIA, and at Mile 2. at the prison, correct?
dafa melni dal yépp ay nuro ci ben anam bi yépp lañ dé jëflanté ak képp ko xamné téé nañ la té fekk kilifa yi ñu ci am aajo non lañ ko défé ci police ba diko défé ci NIA ak ci prison bi tam.
That is correct.
Wa lool non la.
How about the treatment, physical treatment of the person who is arrested and detained at the NIA? What have you learned about such people?
Lan nga jàngé ci façon nit ñooñu nak naka lañ lay jëflanté ak ñoom fekk ñu ngi leen téé ci police bi wala ci NIA.
Oh, I've had many that have alleged torture before confessions are thrown out of them.
am naa ci tawal yu bari yoo xam ne tawal nañ ne dañ leen daan méttital balaa ñooy wax ne li nga xam ne nii loolu lañ leen tuumaal ne ñoom def nañ ko balaa ñu koy nangu.
Could you give us examples?
jox ñu misaal.
For example, the 2006 attempted coup, the suspects.
ci misaal ci atum 2006 coup bu fomm bi nga xam ne ni amoon na fi am na ñaari ñoo xam ne nii dañ leen ci tuumaaloon.
That was the Captain Bunja Dabo and others.
bu mooy Captain Bunja Dabo ak ñeneen.
Ndur Cham.
Ndur Cham.
And which individuals in particular alleged torture?
ñan ci ñoom la wax ne dañ leen doon mitital.
Well, they were tried. The soldiers were tried at the court martial at Yundum Barracks, and all of them, without exception, alleged torture at the NIA.
ñoom nag ñu ngi leen doon attee nag ci
There were about 10, I believe.
soldat bi di court martial bi ci Yundum Barracks waaye ñoom ñëpp dañ tuumawoon dañ waxoon ne daal dañ leen doon méttital.
I have here a report by Amnesty International entitled Gambia Fear Rules.
maa ngi am fii nag kayit boo xam ne Amnesty International ñoo ko bind ci biir Gambia.
And it concerns this case that you're talking of. Part of it concerns this case that you're talking about. And since you participated in the trial, I'll read this out and you tell us what your observations are. And it's alleged torture in the course of treason trial.
Under the
general topic of pre-trial confessions under torture. And Amnesty started with this general statement that torture is used routinely in Gambia to force confessions and as punishment.
Ne mitital day mom dañ koy faral di jëfoo rek biir réewi Gambia pour ñi nga xam ne ñoom lañ bëgg ñu wax wala defal leen ko loo xam ne daal dañ leen koo mbugalee.
In both the military court martial and the treason trial,
ci ñaar yépp ci attekaay bi nga xam ne mooy atte bi ñoo fa ñoo atte soldaar yi ak ñi nga xam ne ñoom la ñoo atte ne dañ doon suufu nguur.
Significant evidence surfaced to suggest confessions had been extracted under torture during the pre-trial period.
am na seede yu wér yoo xam ne feeñ na wane ne dañoo mitital seeni borom pour mun leen a waxloo jamono ji nga xam ne ñu ngi leen di layoo.
Raising concerns about the admissibility of the evidence.
Loolu nag itteel nañu pour mun a xam anam yi nga xam ne noonu la ñoo jotee seede yi.
What's your view on that?
Oh, gisee loolu.
That is very accurate.
nekk na loo xam ne lu jub la.
And you said earlier that almost all of them claimed that they were tortured.
Wax nga fi si gannaaw sax ne daanaka ñoom ñépp wane nañ ne daal dañ leen mitital.
Did you participate in the trial at the High Court of the non-soldiers who were prosecuted?
Bokkoon nga ci layoo bi nga xam ne ñu ngi ko doon def ca High Court ci ñi nga xam ne duñ soldat te ñu yóbbu woon leen ca attekaay ba.
Yes.
Wow.
I believe there were two. I'll say two because Hamadi Sow was extracted from the other lot. He was concealment of treason. For some reason, they wanted to discontinue the case. So he was extracted, so I took him. I was his counsel separately. So there was the bigger trial of Ali Job and others, which I was not part of. But I defended Hamadi Sow against the 2 charges of concealment of treason at the High Court. He was a civilian. He's a civilian.
Hamadi Sow mom civilian la te man mako don baddu di kiko taxawalon ci code bi ci ñaari tuuma ne dafa nëbbatu noppee loo xam ne nii lu jëm ci wàlli suufu nguur la.
Aliou Job and Serigne Omar Fall, they both testified before the commission. They also alleged that all of them were tortured.
Aliou Job ak Serigne Omar Fall ñoom ñëpp joxe nañ seen seede fii te ñoom wax nañ ne ñoom ñëpp am na ay mitital yoo xam ne teg nañ leen ko.
And counsel, they just didn't allege, they actually sometimes showed us injuries that haven't quite healed or have healed, but you can tell when the scar is new.
Counsel, emuñu woon rek sax di tawat ne dañ leen daan métital waaye léegi sax dañ ñu daan won gaañu yoo xam ne nii wér nañ wala wéraguñ bu baax wala ay léget yoo xam ne nii bàyyi nañ ko ci métital yooyu.
How about Hamadi? Was he also tortured?
Naka Hamadi nag moom tamit métital nañ ko.
He was. I think one of his teeth was broken, one of his teeth.
Waaw ndax benn ci bu ñami sax dañ ko damoon.
Yeah.
Would you say that torture was basically a common feature for a lot of the cases, politically charged cases, that were dealt with at the NIA, from your experience?
Ndax ci sa wàllee gis-gis yi nga mun a wax ne daal mbiri mitital ak mbugal yi dañ koy jël di ko teg ñi nga xam ne ñu ngi leen téye ci seen mbir loo xam ne daal mu ngi ànd ak wàlli politique.
From my experience, more in that treason case, in the attempted coup d'etat. I think they were perhaps a bit more ruthless because there were other cases in which there was state interest, so to speak, but there wasn't so much of the allegation of torture.
Man ci suma gis-gis li nga xam ne ni nag mooy tuuma yi ñu leen defal di tegoon di tuuma suufu nguur fa lañ daan gën a ñàkkee yërmande fa lañ daan gën a soxoree ci seen kaw.
I just want to say that it wasn't all cases in which they had interest that torture is alleged, but definitely in that 2006 attempted coup, almost all the suspects alleged severe beatings and severe torture.
ne ko di wax rek ne daal ci yi nga xam ne ni amoon nañ ci aajo amutoon métital waaye nag bu 2006 coup bu fomm bi noonu boobu daal moom ci lañ leen daan gën a métital yu gën a soxore.
Have you participated in other treason trials apart from the 2006 coup?
Gannaaw coup 2006 bi ndax bokkoon nga ci beneen layoo boo xam ne mu ngi aju ci mbiri suufu nguur.
That was earlier in my practice. I came in and found my senior defending Uncle Dumo Saho. That was Ibrahima Barrow, the state and Ibrahima Barrow case.
Mooy jamono bi nga xamee ni commencé na ci wàlli lawyer rek suma kilifa gi jamono boobu mu ngi doon taxawal Dumo Saho di ci keesi Ibrahima
Barrow, the state and Ibrahima Barrow and others.
Ci diggante réew mi nguur gi ak Ibrahima Barrow ci tuuma boobu.
I believe himself and Mamadou Dumo Saho and Marena.
Yaakaar naa ci Mamadou Dumo Saho ak Marena.
That is the case in which Kasso was involved.
Foofu nag ci la Kasso bokkoon.
And in that case, was torture alleged?
Ci jamono boobu nag ndax amoon na ay mitital yoo xam ne tegoon nañ leen ko.
Yes, it was.
Wow.
Mr. Chair, Ibrahima Barrow testified before the commission, and he did describe gruesome torture that he went through, where he was stripped naked and before the NIA leaders, including Usman Sow, and where he was tortured by Alhaji Mor, he said.
I don't know whether he actually also informed the court of when he was removed from Mile 2, taken to NIA, and threatened to change his confession? Okay.
Yes. Were those the only treason trials you worked on?
Yes, those two. Yes.
In a sense, it looks like all the treason trials you were involved in. Let's put them in 3 categories. the first one, that is Ibrahim Barrow and others, Hamidou Sow, Hamadi Sow, and the Bunja Dabo and co. All that said, they were all tortured.
Yes. Mu ngi mel ni yow ci layo yi nga bokkoon yépp ci mbiri ñi doon jéem a suufu nguur ñoom Ibrahima ñoom Hamadi Abunja ñooñu ñépp am na ay mbugal yoo xam ne teg nañ leen ko.
We have had in 1997 the Farafenni attacks. They were tortured.
Dégg nañ ne atum 1997 conga googu ñu daloon ca kaw Farafenni ñooñu tamit am na ay mbugal métit yoo xam ne teg nañ leen ko.
We haven't dealt with the attack in Kartong. But the 2006 Ndur Cham, they were tortured.
Why 2006 coup d'etat Ndur Cham bobu ñoñu tamit mitital nañ leen.
The Ibrahima Barrow treason 2000, those two were tortured.
Atum 2000 bu Ibrahima Barrow ba ñoñu tamit mitital nañ leen.
What's his name again? Landing Sane in 2000, they were tortured.
Landing Sane atu 2000 momit mitital nañ leen.
2009 Langtombong crew, they were tortured.
2009 bu Langtombong ba ñoñu ca bokkon tamit mitital nañ leen.
And 2014 December attacks, those arrested were also tortured.
Atum 2014 weeru December songa nga xamne mo xewon ci diko way burba ñoñ tamit mitital nañ leen.
Council, correct me if I am wrong here. Does it not appear that torture was basically a state policy to be applied to people who were arrested and accused of treason?
Jaajante ma bu fekkee ne juum naa waaye nekkul ne nag lii lu daan faral di am la ñi nga xam ne dañ leen day jàppat leen tuumal suufi nguur daal ñoom saa yu nekk rek dañ leen daan teg ay mbugal yu miti.
I would agree.
Waaw danaa ci ànd de.
And sometimes the clients would tell you words that were uttered as they were being tortured.
Léegi nag client bi sax dana la de nettalil kaddu yi nga xam ne nii moom lañ ko dee wax jamono bi nga xam ne ñu ngi ko doon mbugal.
Such as insults and asking them why they hate the president and why they want to do such and such. So
léegi di ay saaga ak di ko laaj lan moo tax ngeen bañ président bi ak yeneen ak yeneen.
And some would even say that they had instructions to do what they were doing.
Te tamit ñenn ñi sax dañoo wax ne am nañ ndigal pour def li nga xam ne nii loolu lañ doon def.
This is from the clients.
Lii nag mooy loo xam ne nii wax ju tukkee ci client yi la.
We would come back to how the issue of torture or allegations of torture have been dealt with by the courts, especially with regards to confessions that have been extracted as a result of this torture.
Dinañ ñëw ci mbiri mitital yi mbugal yi nga xam ne ñu ngi ko teg naka lañ ko daan jëlee ci attekaay yi su fekkee ne joxe nañ fa ay tuuma ne am na ay mitit yoo xam ne ñu ngi leen ko doon teg.
So let's talk about Mile 2 prisons.
We
have touched upon it, upon that issue as we discussed the other subjects, but let's just come back to it. Especially on the issue of access and general treatment of detainees.
Yes, generally, I didn't have any problem going into Mile 2 to see clients.
Actually,
I had a fairly good rapport with most of the officers, including David Colley. But in instances when you know, for example, in treason cases, which they took very, very seriously, they would sometimes obstruct counsel.
Can you give examples?
Well, there are instances when they would give you some excuse or another, come back tomorrow, come back day after, particularly where in the initial stage of the detention.
léegi nag ñu jox la ay lay demal ba ëllëg nga ñëw wala ba ci beneen bés bi.
And to my mind, over the years of experience, I've come to know that is to perhaps allow time for the suspects for my clients to heal, for example.
waaw léegi nag si suma gis-gis suma xelaat si li ma jàng ci ci suma liggéey as ne lawyer loolu ne mooy jamono boo xamee ne nii pour suma client bi mun a commencé wér.
To heal from what?
To heal from alleged tortures.
mu wéri nag ci métital yi ko teg.
So that was usually a reason for stalling the lawyers having access to our clients at mile 2.
ñaare na loolu dana daan doon dalil li nga xam ne nii mooy tax ñu tere nag council yi ñuy dugg mile 2.
To allow
pour ñu gis ak.
That's my personal opinion.
To allow for cover up of the terrible crimes they have committed.
And it often resulted in them, if necessary, disobeying court orders. They will do that just to buy time.
léegi nag ñu daldi bañ ñi tamit ndigal loo xam ne mu ngi tukkee ci code bi loolu yëpp pour dàq waxtu rek.
In your statement, you cited few examples. Raif Diab, Counsel Mariam Denton, including your own father, with regards to denial of access.
Ci sa kàddu yi joxe nga fi ay misaal Raif Diab ak it Mariam Denton nag sa papa sax yow ci sa boppa ne bañ nañ pour ngeen egg ci ñoom gisee ñoom.
Yes, fortunately for them, my father and Uncle Raif Diab, they were only there for a month.
Suma papa nag ak Uncle Raif Diab ñoom ñu ngi fa woon rek ci dira benn weer.
But not a single time was I allowed access. I or any other lawyer allowed access to them.
waaye nag amul ci benn waxtu boo xam ne ni may nañ ma gis ko wala beneen lawyer ñu may nañ ko mu gis ko.
It took about 5 days after detention for them to even be allowed change of clothing, the two of them.
jël na sax lu dem ci juróomi fan gannaaw bu ñu leen jàppee pour ñu may leen rek ñu wecci mbubb yi ñu soloon.
And these were elderly people.
tey ñii ay mag lañ woon.
For my colleague, she was in there for 3 months.
And
despite court orders for her to have access to her counsel, they repeatedly turned us away. I believe it took over a week before, because I would go there every day with the court order for the release of Mariam Denton, and I would be turned away.
How about the UDP or the protesters of 2016?
Naka nag ñi nga xam ne ñoo doon def ñaxtu boobu ci atum 2016.
I believe the same happened. In fact, after Mr. Dabo and others were arrested and detained, I believe the following day, after, myself, Mrs. Mendy, Boriture and Senior Counsel Mr. Antuman Gay went to the PIU headquarters.
Man ci suma bop ak ñonen ñi nga xamne ñom la tuddu non yépp di ay kalifa ci lawyer dem nañ ci police PIU bi fi.
We were led, I believe it was the Sunday or Sunday or Saturday. We were led by Mr. Gade because we heard that of what had happened and that many of them were injured because the videos were out, them being beaten up in the streets.
Ndax ki ñu jité won na moy Mr. Gade ndax jamono bobu nak vidéo yi wisaaroo nañ ci nit ñi yëpp di seetaan gis ne daal li xew de dañ leen doon dóor ci mbedd mi.
But we were not, we were denied.
waaye nag nangu ñoon ñu gis leen.
And the Solo Sandeng case, also the women who were involved, the women who were arrested and tried, did you have access to them?
ci mbiri Solo Sandeng nag jigéen ñi nga xam ne jàppoon nañ leen yóbbu leen ci court bi ndax mënoon ngaa gisee ak ñoom.
Oh, I think their situation was even worse.
Tell us about it.
In fact, it took a few adjournments for them to produce them in court after the case had come to court.
bi mu àggee nag si court bi sax de jël na ay aj yu bari yenn aj yoo xam ne nii am na balaa ñu ay feeñal sax si court bi.
The men were there, but the 3 women were not in court for about 2 to 3 adjournments.
góor yi ñoom ñu ngi fa woon waaye yeneen jigéen ñi ñoom ñëwuñu woon lu dem si 2 ba 3 aj yoo xam ne ni aj nañ court bi.
Yes, and their names were on the charge sheets.
te seen tur mu ngi woon ci charge sheet bi.
And when they eventually were brought to court, you can visibly see the pain that they were all.
te jamono biñ leen indee ci court bi mun ngaa gis ci sa bët méttit yi nga xam ne ni daal daj nañ ko ci.
That was Fatoumata Jawara, Fatou Kamara, and Nogoy Njai.
boobu mooy Fatoumata Jawara, Fatou Kamara ak Nogoy Njai.
And Fanta Dabo.
ak Fanta Dabo.
And did the case was the case tried in Banjul?
Case bi nag ndax ñu ko doon layoo ci Banjul.
They suddenly, out of the blue, transferred the case, I believe, to High Court Mansa Konko.
mu jéegi ci lañ dal di toxal case bi ca court bu kawe ba nekkee ca Mansa Konko.
Was that normal?
ndax loolu dinañ faral di am.
Very abnormal.
mu nekkul lu jaadu de.
What was the impact of the transfer of the case to Mansa Konko on the issue of access to lawyers?
lan la indiloon nag toxal boobu ñu ko toxaloon foofa ca Mansa Konko lan la jural nag pour lawyer yi mun a gis ci ñoom.
Well, given the fact that most of the lawyers are in the greater Banjul area, all of their lawyers,
lawyer yu bari daal ñu ngi dëkkee fii ci Banjul li ko wër.
and us, the lawyers who were representing them, were here.
te ñun ñi nga xam ne ñoo nekkoon lawyer yi leen doon taxawal ñoom ne ñu ngi yoon fii ñu.
Already attending to 2 or 3 other groups of the same, arising from the same incident.
doon teew na ci ñaar yoo xam ne ni ay képp lañ goo xam ne ñoom it lu mel noonu lañ leen tuumaal rek.
Mr. Dabo's group.
Groupe bi Mr. Dabo.
Second group, Maud Sarr's group, the 3rd group, and the other women also.
di ñaareeli groupe bi bu Maud Sarr ak ñeneen ak yeneen groupe
So it was difficult, if not impossible, for any lawyer to go up there.
dana daan jafe lool pour lawyer mën a dem foofu nag.
So they went unrepresented.
so kon nag looloo taxoon ñoom kenn du leen daan taxaw.
And for a case of that nature, for the accused person to be tried without a lawyer would be a big travesty of justice. Would you think?
Case bobu ak ni mu tolloo mun a aaye borom pour mu gisee ak lawyer bon loolu mel na ne xañ nañ leen li nga xam ne moo di dëgg.
It was contrary to the provisions of the Constitution.
nekk na loo xam ne daal dëppawut ak xate buntu luwaay réewi Gambie.
Because treason carries the death penalty.
ndax suufum nguur nag mën nañ laa atte sax ne dañ lay rey.
For which one is entitled to be, must be represented by counsel.
boo xam ne ni daal yow yelloo nga am koo xam ne dana la taxawal di ab lawyer.
And where one did not have counsel, it was the responsibility.
Sorry. Sorry, it wasn't the treason, but yeah. I just
the charge wasn't.
The charge wasn't there.
All right.
tuuma bi na nekkutoon suufu nguur de.
Okay. All right then.
But they were entitled to have legal representation.
waaye nag yelloo nañ nag ñu am koo xam ne nii mooy leen ay taxawal ci court bi di lawyer.
I mean, the transfer of the case by itself amounted to denial of counsel because it made it basically impossible for lawyers from here to go there to try to defend that case.
nañ toxal àtte gi foofa rek sax mel tekki na ni aaye nañ leen pour ñu gis ak seen lawyer ndaxte dina doon jafe lool pour lawyer yi dem foofu noonu.
Effectively.
waaw.
And in fact, not just their lawyers, but their family members also.
du sax ay seeni lawyer de waaye seen mbokk yi sax dafa yoon na pour ñu dem fa.
In your statement, you talked about the case of KM, a child who was detained at Mile 2 prisons.
ci sa kàddu yi nag wax nga fi lu aju ci KM xale boo xam ne ñu ngi ko jëloon téye ko Mile 2 prison.
Could you tell us more about that?
ñu mun a wax mbir.
Can I just conclude on the last point?
Please, go ahead.
I just forgot to say that I actually went to Janjanbureh prisons where they were being detained, the women, after their case was transferred, and I was denied access to them.
ñaan na rek pour mu jekkali fànn bi mu doon waxtaanee mu ne dem na nag ba kaso gu mag gi nekkee ca Janjanbureh gannaaw boo xamee ne nii seen layoo bi ñu ngi ko toxaloon Mansa Konko waaye nag ba léegi may woon ko pour mu gisanteeg ñoom.
I went there and I was given one excuse after another because they had to get clearance from above and above and above all the way from Banjul.
mu ne demoon na fa nag waaye nag dañ ko doon layal rek ndax boobu ñu ngi doon ut ndigal yoo xam ne mu ngi jóge koo ci kaw toujours ba mujjew daal mën a.
Because we were very concerned. We heard of the dire health situation.
ndax ñun nag soxaloon nañu lu bu baax ndax ñun dégg nañ itamit seen nekkin ci seen wàllu wér-gu-yaram.
It was afterwards, after the case had finished, concluded that I saw Fatou Kamara and she reminded me of that. I didn't know that they could hear me also, similar to what happened at the NIA. Because the premises were very small, but you didn't know where they were, but they could hear me asking for them. And she said that gave them hope.
dal wax na ni tamit ne gannaaw nag loolu ci la gisanteeg Fatou Camara tey tamit nag mu ne am NIA tuuti nan rek waaye ñoom duñ leen dee gis waaye nag ñoom dinañ dee dégg moom mu ngi wax ak lu jëm ci seen mbir te loolu nag yaakaarloo na leen lool.
I can go to, sorry.
Yes, go ahead, go ahead.
No, I was going to go to your question now.
But perhaps
just before you get to that, exactly how many cases were transferred to Janjanbureh and how many to Mansa Konko?
ñaata la yow lañ toxaloon Janjanbureh ak ñaata lañ yóbbuwoon Mansa Konko?
I believe, no, Janjanbureh is the prisons where they were being detained because it's closer to the court.
Sure.
Yes. And I definitely know of the Solo Sandeng group where the women were. Mutsar's group, I don't know whether they were actually in Banjul or it was a very that
yes.
time. I'm surprised I can remember a lot.
Also, some of the men were also transferred to Janjanbureh prison,
yes.
but their trial were being held at Mansa Konko High Court.
Yes.
So they would travel, they will commit to court. You recall we had one of the witnesses say that their pickup truck constantly broke down.
Yes.
I see. Yeah.
Yes.
Okay, fine. Thank you.
Yes. So this experience of denial of access was not limited to just you, I believe. Quite a lot of lawyers in private practice also had similar experiences. Wouldn't you say so?
li nga xam ne dañoo aaye lawyer ñu gisante ak seen client yi emutoon ci yow rek de dal na lawyer yu ci bari ñoo xam ne ñu ngi liggéeyal seen boppa ndax déet.
Yes, because we had one thing in common. We were defending clients that the state didn't want.
Did the Bar Association do anything about this?
mbootaay lawyer yi nag ndax ñoom def nañ dara ci mbir moomu.
Well, it was the Bar Association members who were representing. Are you talking in particular about this case?
No, the Bar Association take this issue up, the issue of denial of access, as one main problem in the criminal justice system.
ndax mbootaay lawyer yi ñoom ekati woon nañ mbir yi itteewoo ko ne wane ne pour aaye lawyer ñu mun a gisee ak seeni client loolu dafa yàq li nga xam ne moo di àtte gi ci biir.
The Bar Association did. I believe you had my learned senior Mr. Tambadou here yesterday.
Yes, indeed.
Bar Association bi def nañ dara ndax dégg nga rek démb suma genn kalifa Ba Tambadou doon wax fii.
I would like to corroborate what he said because part of that time I was a member of the executive of the Bar Association.
Damay gën a dëgëral rek li ma wax ndax jamono boobu bokkoon naa ci kilifa yi nga xam ne nii ñoo seqoon mbootaay googu.
When Mrs. Bensouda, particularly when Mrs. Bensouda was president.
ci rawatina jamono bi nga xam ne Mrs. Bensouda moo nekkoon président.
Letters were written, I mean, any kind of protest that lawyers could have done and maintain their dignity, we had done.
bind nañ ay leetar ak mboolem ñaxtu boo xam ne nii lawyer yi mënoon nañ koo def rek pour nag mën a saxal nag li nga xam ne nii moo nekk seen daraja waaye.
Let me ask another very broad question. Would you say that there was a state policy to torture suspects in treason cases?
Ndax di nga mëna wax ne amon na benn sart boo xam ne dañ ko tëral pour nag nguur gi war di mitital yi nga xam ne dañ leen téye te tuumaa leen suufu nguur.
From the experiences you have.
Ci yow daal ni nga ko gisee.
Sure, from first hand from my clients.
Waaw ci lu njëkk nag ci suma client yi.
And it is my belief because that is what I saw and lived. And that is my belief, is that it was a state orchestrated thing. And a policy, yeah, why not? Because it happened routinely in all of these cases. So. And we were made to believe that they were acting on instructions. And they genuinely believed that it worked. Because they managed to obtain the confessions, which when it gets to the court, the court believes, uses it as basis for conviction. It was as simple as that.
We would come back to the issue of how the courts dealt with the issues of illegally obtained confessions. But in the meantime, you did say that they acted on instructions. Would they tell you where these instructions came from?
Well, they say from the top. Sorry, interpretation. Well, they will tell you that they were acting instructions from the top.
And where do you understand, or what do you understand the top to mean?
Well, they never mentioned the former president, but my belief is that everything came from him, because if you lived in this country, you knew that nobody else dared do anything else. It couldn't have been anybody but him, and if it was anybody, it would have been on his instructions. That is my belief.
Nam duñ daan tuddu turam de waaye nag soo nekkee fii ci réew mi war ngaa xam ne tamit ne de su moyee moom kenn ñemewut sañuta def yu mel noonu.
Now let's go to the case of KM.
Yes.
léegi nag ñu ñëw ci mbiri KM.
Oh, now that case, okay. After Mrs. Mariam Denton's case,
Mrs. Denton,
which the female lawyers of the Gambia came together and defended her, I believe 2 to 3 months after that, we thought we needed to form FLAG, Female Lawyers Association Gambia. Under the leadership of our seniors, Mrs. Bensouda, Mrs. Aida Drame, and Sahawasise Sabali, and others. Janet Salanjai. And so that we could take care of the welfare of our members, one. Promote the welfare of our members, and also offer free legal services to women and children. Particularly those who couldn't afford the services of a lawyer. So we did that in that summer. So there was a time when I believe whether it was the judiciary and the AG chambers personnel went to visit. I remember I think the Chief Justice Ajim was there, and Merle Wood, State Council. They went and paid a visit to the prisons.
Chief Justice Ajim mu ngi fa woon ak Merle Wood.
It's a routine. I wish we could have more of those visits.
They
discovered that there was a young girl there who was about 17 who was never taken to court. And so when they came out, Mrs. Wood, who was instrumental because she's from Ghana, she was a state council and they had FIDA Ghana. So she was very active. That FIDA, that is the equivalent of Female Lawyers Association in Ghana. So she brought it to our attention that there was this girl in there. So we decided to take it up straight away under the leadership of Janet Sala. Myself, I believe myself and Mrs. Sagar Jahate went to visit her. And when she came out and saw us, she sat down. It took her about 2 to 3 minutes before she could talk to us. She was weeping. Her eyes were welled up and she was crying. It could have been more than 3 minutes. We were all emotional, and I felt that spoke for itself. She didn't have to tell us anymore. Because here was this child who got all her rights violated. This has nothing to do with
which ones?
Yeah, this had nothing to do with the state or any interest. This was just a terrible lapse, shall I say. She was 17, still a child. She had spent over 2 years in prison. I believe for a few months initially at Janjanbureh because the incident had happened up country. Then she was taken to Mile 2 where she spent most of the time. Until we saw her. So almost over 2 years in detention without ever being taken to court. Yeah, of course, she was not charged with any offense. She was accused of having killed her husband. I believe she got married at the age of around 13. Before that, and she was being held in an adult prison. Contrary to the provisions of the Children's Act and the Constitution.
Under the Constitution, could she have been lawfully married at 13?
No.
Did it?
Well, that's another issue. The subject to personal law bit comes in, and
the Constitution overrides personal law.
But the Children's Act is specific.
It's specific.
Yes, and with the amendment that was made in 2016, I believe, it specifically now makes it unlawful.
Makes it unlawful.
Ci ni nga xamé non lañ roxandé yenn ci fann ci bunti loi bi nak ci atum 2016 def nañ ko deugal ko itamen muy loi.
The earlier law kind of it was against the earlier law, but this one is more specific. It makes it a crime now.
Exactly. Okay, good. So how did that case end?
Yes, we filed case documents, filed processes in court right away for a habeas corpus, a writ to be issued. So that they can bring her out and produce her to the court first. Yeah, it was Mrs. Njai, myself, Mrs. Jahate, and Ms. Faraj, I believe. And she was brought and subsequently released unconditionally by Justice Almamital. Then of the High Court. But counsel, what was just unbelievable was that there was no trace of the police file even.
Council li nga xamne mo ci gënon na doy war sax mënu ñoo na gis sax file police before.
The State Council had to apply for an adjournment to try to liaise with there was no file.
State Council bi mu ngi doon jema fexé pour joko way dal amuton dal ben file.
So here's this young girl who was arrested, beaten up, taken to prison for over 2.5 years without even a charge or even a police file.
Gi nak moy xalé bu jigen bu ndaw bo xamné ni dal di won nañ ko japp dor ko yobbu ko ci kasso bi ñaari at ak lu tek
big lapse in the way the system was
police file lel nak rek bu dey la won ci ni anam gi daan doxale.
We have seen a lot of violations here. We have heard about a lot of violations, but at least in most of them there would be a case file.
Gis nañ yaxalu waayu ci bari nag waaye nag yi ci ëpp yëpp ñaareel dinay am file boo xam ne ci la ñu bind mbiri case bi.
This one had no case file.
Bii moom amut ci benn.
Well, they couldn't produce it.
They couldn't produce it.
Because after she was produced, the court granted her bail.
Yeah.
Gannaaw buñ ko indee ci court bi daf ko mayoon bail.
To her father. Her father was there.
Ci baayam ndax baayam mu ngi fa woon.
And then we went further to ask the court to declare the arrest, the detention, and the whole works unlawful.
Ci lañ fexe continuer pour nag ci court bi mu déclarer jàpp beeg téye beeg teg benn place bi yëpp ne la dëppawut ak yoon.
So it was during that period that the State Council was trying to find out because they had no idea, and this girl could not be accounted for anywhere.
Ci kaw loolu nag ci la State Council bi commencé nag di daw ak dikk ci ngir seet xale bi amul fan foo xam ne nii fi lañ bind ay mbiram.
Wow, that was a serious lapse in
that was serious.
loolu moom xare bu rëy la woon.
I know that I personally took it upon myself to advocate for, and actually after that case, I had a few other cases in which as soon as they remand the girls in Mile 2, they were removed and taken to the shelter, because that is what the law says. They should not be detained together with adults. And you get told that we don't have the facility. At least you have Joshua for the boys, but you don't have anything for the girls, and so that is serious.
So did you take it a step further by asking for compensation for the unlawful detention?
Ndax am nga yeneen jéego yoo xam ne na jëloon ngeen ko ci pour laajte ndàmpaay pour xale bu jigéen boobu ngir téye biñ ko téye ak liñ ko def te benn àndu ci ak luwa.
We didn't, because the father was just happy that he's got the daughter back and didn't want any, in fact took her far away.
Defuñ ko nag ndax baay ji daal kontaanoon na rek ne jotaat na doomam ci jamono boobu.
I asked this question because it would be interesting for the commission, at least if that person were to file a complaint with the TRRC for the violation of her rights.
Okay.
Waa dama laajte loolu nag mooy dina itteel TRRC bu fekkee ne xale boobu dal dina binda pour joxe tawat ne dañ yàq li nga xam ne moo di yelleefam.
The father kept in touch for some time, but then I've lost touch with him, but he knows where I am, so maybe he's watching and he can come forward.
Bayam nak dañ daan jokkoo waaye mu jégi daal jokkoo bi dog na waaye nag moom xam na fi ma nekk te xëy na sax mu ngi seetaan nag ci jamono ji.
Mr. Chair, perhaps this is a convenient time to stop for the first break, and we would come and try to finish before lunch.
Yeah. So she went with her father. She was not taken to the shelter, was she?
Léegi dafa ànd ak papaam yóbbuwuñ ko fi nga xam ne fa lañ leen denc xale yi.
No, after she didn't get to go to the shelter. She was after the writ was issued for her production to the court. Yes. That's how she left Mile 2, and then she was unconditionally released. So she went home with the father. And there were subsequent cases in which young girls had been taken to remand, and upon protest, I know I've protested, they've been removed and taken to the shelter to be detained there because they were accused of murder, yeah, which was not bailable.
And was there a monitoring system in the shelter?
Can I just say that eventually I managed to get all of them bail. There was not much there. There was not much there, but they were aware that these children were there in the custody of, under the custody of the court.
Thank you very much.
But I got them, the two that I had, I got bail as soon as possible because the Children's Act allows that.
Indeed.
For that, even if you're charged with murder.
Good. Thank you. We'll take a 30 minutes.
That's an
break.
important exception.
Yes.
Indeed.
Very important.
We will take a coffee break and come back at 12:30.
Okay.
Thank you very much. Meeting is adjourned.